Part 1 Facts. The court case we researched was the United States v. Causby. This was a U.S. Supreme Court case dealing with the ownership of airspace above an individual's property. The respondent, Thomas Causby, owned a home less than a half mile from the end of a runway in North Carolina. His house with a chicken coop was right under the safe path of glide for the airplanes. This case was happening during 1946, so during this time there were many military aircrafts that used the runway. Causby claimed that they would come so close to his property that they would just miss the trees. The article United States v. Causby on the website Justia states the noise was startling and the glare from the landing lights lighted the place up brightly at night. This destroyed the use of the property as a chicken farm and caused loss of sleep, nervousness, and fright on the part of the respondents. This terrified the chickens so bad that some of them stopped laying eggs and some ran into their coops where they later died. Causby lost 150 chickens and had to stop his business. Part 2. The issue. The main issue was whether or not Causby's property was taken within the meaning of the Fifth Amendment. A property owner has the right to prohibit public use of airspace above the owner's land that interferes with his right to light, air, view, or the safe and peaceful occupation and enjoyment of his land. The Causbys sued the U.S. in the Court of Claims for alleged taking of Causby's property and for damages to their poultry business. He sued the government for compensation under the Fifth Amendment's taking clause. The Court of Claims found that the government took an easement over the property and Causby had damages to his property estimated at $2,000.
The question at hand, in United States v. Causby, was whether or not the flying of the planes by the United States military over Causby's farm constituted a violation of the Takings Clause of the Fifth Amendment. Now, the answer to this the court came to was yes, but to an extent. In a 5-2 opinion authored by Justice William O. Douglas, the court concluded that the ancient common law doctrine, quote, has no place in the modern world, end quote. Justice Douglas also noted that were the court to accept the doctrine as valid, quote, every transcontinental flight would subject the operator to countless trespass suits. Common sense revolts at the idea, end quote. However, while the court rejected the ultimate reach above and below the earth described in the common law doctrine, it also ruled that, quote, if the landowner is to have full enjoyment of the land, he must have exclusive control of the immediate reaches of the enveloping atmosphere, end quote. Now, without defining a specific limit, the court stated that flights over the land could be considered a violation of the Takings Clause if they led to a direct and immediate interference with the enjoyment and use of the land. Now, given the damages caused by the particularly low frequent flights over his farm, including the noise ordinance at night, the light ordinance at night, the excessive noise given off at any time when the planes were landing or taken off, and also the fact that his chicken population was cut down due to them flying into the wall because of fright, the court determined that the government had violated Causby's rights and he was entitled to compensation.
After reviewing the facts essential to the case in question presented, the Court of Claims considered both the economic and emotional losses suffered by the Causbys. The airport being used by Army and Navy aircraft located only about 2,200 feet from their barn and house featured a path of glide to its runway passing directly over the property considered. The 30-to-1 safe glide angle for this runway was prescribed by the Civil Aeronautics Authority, an agency of the federal government that calculates ideal regulations of descending meters per second based on speed and weight of an aircraft. Although the aircraft's landing procedure itself was considered legal, the legality of the alarmingly close proximity in which these military planes were flying over both trees and structures on the Causby's property was still up for debate. Beginning in June 1942, in order to assist in transporting soldiers and equipment during World War II, the United States used the runway in question for landing around 7% of the time between then and when this case was presented in court. This percentage seems rather minuscule when considering the monetary damage claimed by the property owners. However, these planes were not the only military aircraft with a flight route passing directly over the land owned by the Causbys. In fact, the emergence of aerial navigation by the U.S. military over the property commenced as early as May 1942. Planes as massive as the 4 motorized heavy bombers used during the war passed over the residence, appearing so shallow in altitude that they barely missed the tops of their trees, and at times were low enough to blow the leaves right off of them. The disturbingly loud noise resulting from these occurrences not only startled the property owners and deprived them of many nights' sleep, but also caused the deaths of as many as 6 to 10 chickens for their poultry business in one day by making them fly forcefully into the walls of the barn from fright. The Causbys lost over 150 chickens in this manner. This was severely detrimental to production and resulted in the destruction of property as a commercial chicken farm. The Court of Claims, on the basis of these facts, found that the property itself had depreciated in value. It held that the United States had taken an easement, or legal right to pass for a specified purpose, over the property on June 1, 1942, as permitted by lease to do so at that time. The court determined, under the Fifth Amendment, that the value of the property destroyed by the easement was $2,000. However, Supreme Court Justice Hugo Black did not agree, and the Supreme Court granted a petition to review the Congressional Court of Claims ruling. The United States relies on the Air Commerce Act of 1926, amended by the Civil Aeronautics Act of 1938. Under these statutes, the United States has complete and exclusive national sovereignty in the airspace over this country. They grant any U.S. citizen a public right of freedom of transit in air commerce through the navigable airspace of the United States, defined as airspace above the minimum safe altitudes of flight prescribed by the Civil Aeronautics Authority. It was initially argued that the flights in question were within the prescribed minimum safe altitudes of flight and that they were an exercise of the previously declared right. Also, it was contended that since there was no physical invasion of the property, there had been no taking of the property by the authorized air navigation. Evaluating ownership of airspace dates back to an ancient doctrine, in contrast to modern views, stating that common law ownership of land extended from the surface infinitely to the universe beyond it. Since this doctrine has no place or influence in the time period of the case in question, the Court of Claims circled back to the accusation of an easement of flight taken. They claim that even though the planes did not touch the surface of the land, the facts of the case depicted the destruction of the owner's right to possess and exploit their property as desired. Referencing the case of Portsmouth Harbor Land and Hotel Company versus the United States, it was stated by the court that the use of airspace immediately above the land would limit utility of such land, causing its value to diminish. The court then pinpointed that path of glide governs only operations of landing or taking off, and the authorized safe path altitude does not apply to flights passing over the property in continuous route. Because of the flights in question being tremendously lower in altitude than the actual minimum safe altitude of 500 feet during the day and 1,000 feet at night, the court held that continuous invasions of airspace at such low altitudes limits landowners from full use of property and are valued in correspondence with invasions of the land itself, hence a partial taking estimated at $2,000. Justice Black had opposing views entirely. He proposed that constitutional amendments regarding air transportation shall govern only the preservation of freedom of air travel, and that legislative history encourages that the Civil Aeronautics Authority shall remain in control of the prescription of air traffic rules, including the authority to regulate the landing and taking off of aircraft. He urges that solutions to issues in the realm of the one in question cannot be determined by creation and application of constitutional restraints, and that the Congressional Court only take part in the awarding of damages for injuries suffered from the flying of planes or by granting injunctions to prohibit their flying. He concludes that the issue questioned by the case presented should be separately brought to and addressed by the Civil Aeronautics Authority, and that under the Fifth Amendment, there has been no financial taking from the landowners in the constitutional sense.
Good afternoon, my name is Shabria Williams. Today I will be explaining how our case relates back to the critical thinking quote. The Court of Claims held that there would be taking and entering judgment for responses. The judges agreed that the circumstances would be taken. Military airplanes are subject to rules. This meant that there was no Navy or Army regulations. This relates back to the quote in many different ways. One way is because being that they don't have any rules, that was a terrible behavior, and it was harder for people to get in trouble.